Section 16 of the Watergate Report, Volume 3. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. The final report of the Senate Select Committee on Presidential Campaign Activities, Volume 3. Chapter 8, The Hughes-Rebozo Investigation and Related Matters, Part 9. 8. Return of the Hughes Contribution. George P. Shultz, Secretary of the Treasury, received a sensitive and confidential memo from Johnny M. Walters, Commissioner of the Internal Revenue Service, on February 23, 1973. The purpose of this memo was to alert Secretary Shultz that the IRS investigative team had concluded that there was a need to interview Charles B.B. Rebozo. Shultz sent this information to John Ehrlichman. In this memo, Walters explained that the IRS had received testimony from Richard Danner about a political contribution Danner made on behalf of Howard Hughes to Rebozo. While the IRS had received this testimony from Danner on May 15, 1972, a formal request to interview Rebozo was not made until February 23, 1973, 10 months later. Although field agents of the IRS had requested permission to interview Rebozo as early as the summer of 1972, these requests were not authorized until April of 1973. According to Walters, this delay resulted from a policy decision that he and other top-ranking officials within the IRS made during the summer of 1972. The IRS had concluded that in an effort to conduct business as free of politics as possible, all matters that were politically sensitive would be postponed until after the 1972 elections. When requests were made to interview Rebozo during the summer of 1972, these requests were postponed by Walters personally in accordance with the above policy. Requests from the IRS field agents to interview Rebozo came to Walters on a continuing basis. On February 22, 1973, after the elections, Johnny Walters discussed these requests with William Simon, who at that time was Deputy Secretary of the Treasury. Simon suggested that Walters compose a memo for Secretary Shultz, informing him of the need the IRS had to interview Rebozo. According to Walters, Simon told him that Secretary Shultz would be meeting with President Nixon later that day in Camp David, and the IRS's request to interview Rebozo could be brought to the president's attention during this meeting. At the time, the IRS wanted to talk with Rebozo only to verify information with regard to whether he had received $100,000 from Danner. Walters stated that the purpose of this memo was not to ask for permission, but merely to alert the administration that Rebozo was to be interviewed by the IRS. Walters emphasized, however, that the request to interview Rebozo would be postponed until Walters himself received the go-ahead from Secretary Shultz. As of March 8, 1973, Walters still had not heard from Shultz concerning his request to interview Rebozo. Walters, therefore, spoke again with Simon to emphasize the need to interview Rebozo. Walters finally received approval from Shultz on April 7, 1973. Although Walters did not officially inform the White House of the IRS interest in Rebozo until February of 1973, the White House actually had received this information as early as the spring of 1972. Sometime between March and June of 1972, a sensitive case report which mentioned the names of Don Nixon, Charles B.B. Rebozo, Larry O'Brien, and others involved in the Hughes investigation was brought to John Ehrlichman's attention by Roger Barth, who was an assistant to the Commissioner of the IRS. Barth, in fact, provided a copy of the sensitive case report to Ehrlichman. Barth testified that Ehrlichman requested to be kept informed as the case progressed and expressed specific interest in Larry O'Brien's involvement. Ehrlichman recalls that he was continually receiving sensitive case reports concerning the Hughes investigation, but that he did not tell Rebozo of the IRS interest in Rebozo until Barth requested him to do so. After Walters received a go-ahead from Schultz concerning the IRS request to interview Rebozo, Walters asked Barth to notify Rebozo of this. Before notifying Rebozo, however, Barth first spoke with Ehrlichman to get his approval of this matter. Ehrlichman has testified that when the sensitive case report came over, it came over with a note from Barth saying that I need to talk to you about this, and so I immediately called him, and he said at that time, I need to have a green light on interviews of Rebozo. I said, okay, I think it is from my standpoint indicated. I will give you the green light if you are satisfied with that. According to Barth, he met with Ehrlichman, and Ehrlichman showed him a copy of Walters' February 23, 1973 memo. Ehrlichman asked Barth if Rebozo was in trouble, and Barth explained that as far as he knew, this was just a third-party interview and that the IRS was not planning to do an audit or criminal investigation of Rebozo. With these assurances, Barth has testified that Ehrlichman approved the interview. Ehrlichman has testified that because of the close relationship between Rebozo and the president, Barth was reluctant to call Rebozo directly. Ehrlichman, therefore, agreed to call Rebozo. Shortly after Rebozo was informed by Ehrlichman that the IRS wanted to interview him, Rebozo began to make a concerted effort to return the $100,000. Rebozo testified that in March and April he attempted to contact Richard Danner to arrange for the return of the contribution. Danner, however, does not recall any contacts between Rebozo and himself concerning the return of this money until May 1973. While Rebozo discussed his decision to return Hughes's contribution with various people, including the president, Rebozo has testified that the ultimate decision to return the money was his alone. Rebozo testified that after Hughes left Nevada in November 1970 and fired Mayhew, Rebozo became very apprehensive about the Hughes contribution. So as time went on, Rebozo, just thought it better not to use that money for the 1972 campaign and try to see if things cleared up, and to hold it for the 1974 or 1976, some point where I could turn it over to the properly appointed authority. But matters went from bad to worse with the Hughes organization. Rebozo was also very concerned that this Hughes contribution would be disclosed, and then any association between Nixon's 1972 campaign and Howard Hughes would be a source of embarrassment to the president, as it had in his 1960 campaign. Rebozo testified that, I didn't want to risk even the remotest embarrassment of Hughes's connection with Nixon. I was convinced that the Hughes loan to Don Nixon cost the president the 1960 election and didn't help him in 1962 in California. Although Rebozo claimed that dramatic organizational changes within the Hughes organization caused him concern, he made no effort to discuss this in the context of the contribution with Danner or any other Hughes employee, nor did he seek advice from any administration or campaign officials. Finally, when Ehrlichman told Rebozo that he was going to be interviewed by the IRS, Rebozo began to make a concerted effort to return the money. Although Rebozo said the contribution was for President Nixon, he had been hopeful that this campaign contribution could be used in 1974 or 1976. Now, with the IRS requesting to interview him, Rebozo decided that the money could not be used for any campaign purposes, and that the best course of action would be to return it. Rebozo has testified that he discussed the Hughes contribution with the president on 2 occasions prior to its return. The first conversation took place in Key Biscayne sometime after the 1972 presidential election. During this conversation, Rebozo has stated that he explained the whole picture to President Nixon. Rebozo testified that he could not recall what the president's reaction was to this information, but stated that President Nixon did not offer any advice about whether or not the money should be returned. Rebozo's second conversation with President Nixon was in March or April 1973. This discussion occurred after Ehrlichman had told Rebozo that the IRS would be interviewing him. Rebozo has testified that during his second conversation with the president, Rebozo told him that he had decided to return the Hughes contribution, and that President Nixon agreed with his decision. Rebozo has testified that the next conversation which he had was with Herb Kalmbach on April 30, 1973. The Senate Select Committee has interviewed Rebozo 3 times and also questioned him in a 2-day executive session. While Rebozo, in each of his sessions with the committee, spoke freely about his conversation with Kalmbach on April 30, 1973, he never once asserted that his conversation related in any manner to information which he later claimed was protected by the attorney-client privilege. Rebozo has testified that while he was in the West Wing of the White House on the morning of April 30, 1973, he ran into Kalmbach in the halls. According to Rebozo, their meeting was not arranged and Rebozo was not seeking Kalmbach's advice. Rebozo testified that, "I think it was just a general discussion. You see, Kalmbach and I have numerous discussions, naturally on the San Clemente interest. He and I worked on the Yorba Linda house and Whittier property. We talked about things like that. I believe I told him about the Hughes contribution. He had been involved in fundraising and it wasn't going to be any secret. I guess I just felt the key people should know about it." During an interview with the Senate Select Committee on October 17, 1973, Rebozo stated that he did not ask Kalmbach for any advice or counsel concerning the return of the money, because by April 30, 1973, the decision was already made. If I did ask, it was just for his opinion. As I recall, the part about the Hughes money was just an irrelevant part of the conversation. During an executive session on March 20-21, 1974, Rebozo testified that on April 30, 1973, he did ask Kalmbach for his judgment, and Kalmbach told him he thought Rebozo should give it back. Rebozo does not recall discussing this topic again with Kalmbach. Kalmbach was also questioned on 3 occasions by the committee concerning his meeting with Rebozo on April 30, 1973. In each of these sessions with the committee, Kalmbach responded to specific questions about this meeting and indicated that it related to discussions concerning the refinancing of San Clemente and the issue of whether the $100,000 was used in the purchase of San Clemente. During these first 3 interviews with the committee, Kalmbach never asserted an attorney-client privilege concerning his meeting with Rebozo on April 30, 1973. On a 4th and 5th occasion, in an interview on March 8, 1974, and an executive session on March 21, 1974, Kalmbach for the first time refused to testify with regard to this specific conversation because of attorney-client privilege. Senator Ervin, however, on March 21, 1974, ruled that, based on the above-described testimony of Rebozo, he and Kalmbach had not entered into a valid attorney-client relationship. Because of the significance of Kalmbach's testimony pursuant to Senator Ervin's instructions, it is set out at length as follows. Sometime during the week of April 23, 1973, Bibi Rebozo called me at my office in Newport Beach, I think he was calling from Key Biscayne, and told me he had a matter he wanted to discuss with me, and asked when I would be next in the East. I told him I too had some items I wanted to go over with him, and that I was scheduled to be deposed in Washington at 10 a.m. Monday, April 30th, and perhaps we could meet sometime during my 1 or 2 day stay in the capital. Rebozo said he would be in Washington over the weekend and suggested that we get together Sunday evening, April 29th. At about 7:30 on Monday morning, April 30th, I took a cab from the Madison to the Pennsylvania Avenue front gate entrance of the White House. The person on the desk called BB and announced my arrival, and within 5 or 10 minutes he came out and met me. He decided we should use the fish room, which is just off the lobby. We went together and sat in the corner nearest the door. After we had spent 10 or 15 minutes covering various points, BB went into the matter he wanted to discuss. BB said the president had asked him to speak to me about this problem and not Maurice Stans. He said he had personally received $100,000 in campaign contributions from Dick Danner, representing Howard Hughes. He said that he had received 2 cash contributions of $50,000 each in 1969 and 1970. He said that the IRS had scheduled a meeting with him on this very subject, which would be held 2 or 3 weeks hence. He said that he had disbursed part of these funds to Rose Woods, to Don Nixon, to Ed Nixon, and to unnamed others during the intervening years, and that he was now asking for my counsel on how to handle the problem. In response to my questions, he reiterated that the money had been given to him as a contribution by Hughes, and that the expenditures he had made to the several individuals, including Rose and the president's 2 brothers, had come from the Hughes cash. I then said that my advice was that he should get the best tax lawyer he could find and give him not only the entire story, but also the balance of the Hughes cash for return to Hughes, and a list of everyone to whom he had given money from these funds, to which list should be attached whatever backup could be obtained to show the use to which the funds had been put by the recipients. I said that he and his attorney should then lay the facts of the matter out exactly to the IRS. In reply to my advice, BB expressed grave reservations about doing so, for the stated reason that this touches the president and the president's family, and I just can't do anything to add to his problems at this time, Herb. I then said I would like to check the validity of my advice with Stanley Ebner, who I identified as the then general counsel at OMB in the White House, indicating further that Stan had been counsel to Maurice Stans's finance committee during the 1972 campaign, and that he had begun his duties with Stans after the new finance law took effect on April 7, 1972. BB was very queasy about me talking to anyone about this matter, and I assured him I would not mention his name to Stan and would talk to him only on a hypothetical basis. Finally, BB agreed, and we said goodbye to each other after agreeing to meet the next morning at 8:30 in the lobby of the West Wing of the White House. Immediately after BB and I parted, I used the phone in the lobby and called Stan at his office in the Executive Office Building. I found him and in response to my request for a few minutes of his time, he suggested that I come right over. I went over to Stan's office about 9 o'clock, and after a very brief exchange of amenities, I asked him to let me check my judgment against his as to a special situation that had arisen. I then recounted the facts as earlier expressed to me by BB. Stan agreed completely with what I had advised BB and expressed himself that he could not see any other course. I again met BB the next morning. I arrived by cab from the Madison and was in the lobby around 8:30. When BB came out to see me, I remember that we wandered around the lobby floor looking for a private meeting place. Finally, with Rose Woods along, we went into a small room on the ground floor of the West Wing. Rose left us, and we sat down behind a closed door. I began recounting my visit to Stan, including his confirmation of my suggested course of conduct for Bibi to follow. Before I had completely finished, Bibi cut short any further discussion of the matter with a somewhat baffling comment that he saw no problem, but he thanked me for my thoughts. Our entire conversation that Tuesday morning did not last longer than 15 or 20 minutes, and I recall that I left the White House around 9 a.m. Ebner has stated that he did meet briefly with Kalmbach on April 30, 1973. Ebner recalls that Kalmbach discussed a hypothetical situation at that time. Ebner cannot recall specific hypothetical facts furnished to him, since Kalmbach apparently discussed hypothetical situations with him on a number of occasions. In a sworn affidavit, James O'Connor, Kalmbach's attorney, stated that following the meeting with Rebozo, Kalmbach immediately told O'Connor all the details of this meeting, including the fact that Rebozo had disbursed some of the $100,000 Hughes campaign contribution to Rosemary Woods and the Nixon brothers. In October 1973, after Kalmbach was interviewed by the committee, O'Connor dictated a brief memo to his secretary, Margaret Blakely, which he then asked her to read over the telephone to Rebozo. The purpose of this memo was to inform Rebozo that Kalmbach had acknowledged to the Senate Select Committee that he had met with Rebozo on April 30, 1973, that he had testified that the prime purpose of the meeting was to review certain matters involving the President's personal affairs, and indicated that Kalmbach had not given any additional information concerning this meeting to the committee. On January 26, 1974, O'Connor once again asked his secretary to call Rebozo and tell him that if Kalmbach was pressed as to any details of a conversation between himself and Rebozo on April 30, 1973 and/or May 1, 1973, that he would state that the discussions were pursuant to the attorney-client relationship. Margaret Blakely has also provided a sworn affidavit to the committee that on 2 occasions she was requested by O'Connor to contact Rebozo. According to Blakely, both O'Connor and Kalmbach felt it best if she contacted Rebozo rather than either of them, and that if Rebozo had any questions, she would attempt to get the answers for him. During her first conversation with Rebozo in October 1973, she was simply advising him that Mr. Kalmbach was asked on October 12th by Mr. Lenzner to furnish the number and location of all bank accounts in the name of the President and on which he was a signatory, that Mr. Kalmbach was concerned about any possible violation of the attorney-client privilege, that Mr. Kalmbach was questioned by the Special Prosecutor's Office and by Mr. Lenzner on October 11th and 12th as to a meeting on April 30th with Mr. Rebozo, and Mr. Kalmbach had acknowledged that the meeting took place at or about that time. Mr. Kalmbach further advised both investigative bodies that the prime purpose of the meeting was to review certain matters involving the President's personal affairs, including the sale of the Whittier property and the refinancing of the San Clemente property, among other things, and that Mr. Kalmbach was disturbed about reports that campaign funds were used in the acquisition of the San Clemente property. Blakely's second conversation with Rebozo was on January 25, 1974. At this time, she told him, "If Mr. Kalmbach is pressed as to any details of a conversation between himself and Mr. Rebozo on April 30th and/or May 1st, he, of course, would have to tell the truth. That in the unlikely event he is pressed on this matter, he will, of course, state that these discussions were pursuant to the attorney-client relationship and therefore subject to the attorney-client privilege." Blakely indicated that during both of her conversations with Rebozo, he made no comment and had no questions. Although Rebozo has denied any other conversations with Kalmbach concerning this matter, Kalmbach has testified that A third meeting was held with Beebe on Tuesday morning, January 8, 1974. He and I had talked by telephone once or twice after he arrived in San Clemente to be with the President during his stay in California. Never at any time during these telephone conversations did Beebe mention, directly or indirectly, our discussions in the White House on April 30th and May 1st. Finally, he called and asked me to meet with him on Tuesday, January 8th. I agreed to meet him at 8:30 in the morning at the mess in the Western White House. On that date, when I arrived at the gate, the guard told me that Mr. Rebozo had left word that I should proceed directly to the guest house in the living compound. This I did, and arrived at the guest house, which is directly across a court from the President's quarters, at 8:30. When I entered the guest house, Beebe told me the reason he had switched our meeting place was because he had learned that a great number of the press were over at the offices, and we would be afforded greater privacy within the compound. Our meeting lasted for about 1 hour and 15 minutes and ranged across a number of subjects. At one point, somewhat near the end of the meeting, Rebozo said words to me to the effect that, "Undoubtedly, Herb, I've not told you that after you and I talked last spring regarding the Hughes money, I found that I had not, in fact, disbursed any of the Hughes cash to the several people I named. When I went to the safe deposit box, I found that the wrappers around the cash had not been disturbed, and so it was clear that no part of this money had been used during the several years it was in my box." I didn't make any comment at all to Beebe when he made this statement, other than to acknowledge what he had said. We then went on to other items on the agenda, and I left him around 9:45 and drove up to Los Angeles. End of section 16. Recording by Maria Casper.
Section 17 of the Watergate Report, Volume 3. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. Final Report of the Senate Select Committee on Presidential Campaign Activities, Volume 3. Chapter 8, The Hughes-Rebozo Investigation and Related Matters, Part 10. In late April or early May 1973, Rebozo called William E. Griffin and asked Griffin to fly to Florida to discuss a problem that Rebozo had. Rebozo did not indicate what the problem was, except that he had something he wanted to discuss with Griffin that was very important. Griffin met with Rebozo in Florida on May 3, 1973, where Rebozo told him for the first time of the Hughes $100,000 campaign contribution. According to Griffin, Rebozo told him that he had received two $50,000 cash campaign contributions from Richard Danner. These contributions were made in 1969 and 1970. Rebozo also explained to Griffin that he had maintained the $100,000 in a safe deposit box and that he still had the identical bills which Danner had earlier given to him. Rebozo's concern at this time was how he should handle the matter with the IRS. Griffin testified that he did not offer any advice to Rebozo during the May 3, 1973 meeting because he wanted an opportunity to research certain problem areas which he felt Rebozo may have had concerning his retention of the $100,000. Griffin stated he told Rebozo he was concerned with problems of unreported income, gift tax, campaign statutes, and the election statutes. Griffin testified he could recall that Rebozo stressed that the bills in his safe deposit box were the exact same bills he received from a Hughes representative in 1969 and 1970. Griffin testified he returned to New York to do some research for Rebozo. In early May 1973, Griffin met again with Rebozo at Key Biscayne. Griffin testified he told Rebozo that he should immediately obtain an independent individual who could act on Rebozo's behalf to count the money, identify the bills, verify that the money was in a safe deposit box, and that this individual should arrange for the return of the money. Rebozo, according to Griffin, accepted his advice and asked Griffin if he could act on Rebozo's behalf. Griffin declined because of his close association with Robert Abplanalp, who was also a very close friend of the president's. Griffin felt that any representation made on Rebozo's behalf would be tainted with partisanship. According to Rebozo, he did not discuss the return of the Hughes contribution with William Griffin. Rebozo, however, did not recall ever asking Griffin to act in Rebozo's behalf to facilitate the return of the money, nor could Rebozo recall any specific advice Griffin offered to him concerning the need for an independent third party to arrange for the return of the money. Rebozo does recall that Griffin did some research for him and then later advised Rebozo to turn the money back. On May 10, 1973, Rebozo was interviewed by IRS agents Donald Skelton and Albert Keeney. The agents explained to Rebozo that they were investigating the Hughes Tool Company, Robert A. Maheu, John Mayer, and other people associated with the Hughes Association, and that their purpose of interviewing Rebozo was to verify some information that they had received concerning a campaign contribution which had allegedly been given to Rebozo by Richard Danner. Rebozo told the agents that he had, in fact, accepted a contribution from Richard Danner and that he still had the money in a safe deposit box. According to the IRS, Rebozo stated that the only persons who knew of the Hughes contribution were Rebozo and the agents. Rebozo also told the IRS that he had considered contacting Danner in an effort to return the money, but did not do so because he feared additional publicity. Rebozo has testified that he cannot recall when he first told Danner that he wanted to return the money, but stated he believed he told him in March or April 1973. Rebozo, however, later testified that it was not until after his May 10, 1973 interview with the IRS that he actually tried to contact Danner and ask him to take the money back. Danner has stated that he met with Rebozo in Las Vegas, April 1973, but that this meeting was purely social. According to Danner, there were no discussions about the return of the Hughes contribution at this time. Danner has testified that he specifically recalls the first conversation he ever had with Rebozo concerning this matter took place over the weekend of May 18th to 20th, 1973. Rebozo also recalls meeting with Danner at this time and discussing the return of the Hughes contribution. During an executive session with the committee, Rebozo testified as follows concerning his May 18th to 20th, 1973 meeting with Danner. 1. Over the weekend of May 18th to 20th, 1973, Rebozo stayed at the Madison Hotel where he met with Danner and discussed the return of the Hughes contribution. 2. According to Rebozo, both he and Danner were in Washington to attend some social function, but Rebozo cannot remember what it was. Rebozo did not request Danner to come to Washington. 3. In addition to discussing the return of the Hughes contribution, Rebozo and Danner also discussed the political feelings on the West Coast concerning Watergate. 4. Rebozo left Washington on May 19, 1973 to join President Nixon at Camp David. On May 20, 1973, Rebozo invited Danner to come to Camp David and discuss with the president what the political feelings were on the West Coast. Rebozo arranged for a White House limousine to pick Danner up and drive him to Camp David. 5. Danner met with Rebozo for approximately 1/2 hour before the president joined them. Prior to the president's arrival, Danner and Rebozo discussed the return of the Hughes contribution. Throughout the weekend, Danner refused to accept the return of the Hughes contribution, but promised Rebozo he would talk to his superiors and arrange for it to be returned. 6. The president joined Danner and Rebozo in Rebozo's cabin at Camp David and remained with them for approximately 5 to 10 minutes. During their conversation, there was no mention of the return of the Hughes contribution. The only subject which Danner discussed with President Nixon was the political mood on the West Coast concerning Watergate. 7. After the president left, Danner and Rebozo visited for a short while and then Danner returned to Washington. 8. On May 18, 1973, Danner, Rebozo, and Mr. and Mrs. Abplanalp flew to the Adirondack fisheries in Abplanalp's private jet and had lunch. After lunch, Danner and Rebozo returned to Washington. While they were with Abplanalp, there was no discussion whatsoever concerning the Hughes contribution. Danner testified as follows concerning his May 18th to 20th, 1973 meeting with Rebozo. 1. Danner met with Rebozo in Washington during the weekend of May 18th to 20th, 1973, at Rebozo's specific request that he do so. 2. Danner met with Rebozo at the Madison Hotel, and during this meeting, Rebozo told him for the first time that he wanted to return the $100,000 Hughes contribution. This information came as a complete surprise to Danner. 3. Danner refused to take the money back because he felt it wasn't his money to accept. Danner promised Rebozo that he would take the necessary inquiries to determine who the money should be properly returned to. During this weekend, there were extensive conversations between Danner and Rebozo concerning the return of the Hughes contribution. 4. Danner has testified that he also spoke with Rebozo about the political feelings on the West Coast concerning Watergate. Rebozo asked Danner if he would stay over and come to Camp David on the following morning. Danner agreed. 5. On May 20th, 1973, Danner met with Rebozo at Camp David and, prior to the president's arrival, discussed the return of the Hughes contribution. Danner once again refused to accept the return of the money. 6. After the president joined Danner and Rebozo in Rebozo's cabin, there were no discussions of the Hughes contribution or any other campaign contributions. During their meeting, Danner expressed to the president what the political feelings were on the West Coast. After the conversation, the president took Rebozo and Danner on a brief tour of Camp David. 7. Danner's meeting with the president and Rebozo lasted 1 to 1.5 hours. 8. After the president left, Danner and Rebozo had lunch together, and then Danner returned to Washington. 9. Danner testified that he has never discussed the Hughes contribution with President Nixon. 10. On May 18, 1973, Danner, Rebozo, and Mr. and Mrs. Abplanalp flew to the Adirondacks in Abplanalp's private jet to have lunch. While the four were together, there were no discussions concerning the Hughes campaign contribution. Deputy Press Secretary Gerald L. Warren, in a statement made to the press on January 26, 1974, stated that Mr. Danner was in Washington to talk with Mr. Rebozo and did pay a brief visit to the president at Camp David. The meeting lasted only 5 or 10 minutes, and Danner reported on the mood of the people in the West. General Haig testified that while he was not aware at the time that Danner and Rebozo met with President Nixon at Camp David on May 20, 1973, he learned of it when it became a public relations issue in the White House. Haig discussed this matter with Ron Ziegler, who informed him that the purpose of the meeting at Camp David was to enable Danner to express his support for the president at a time when the president had been under heavy attack. Ziegler stated to Haig that he had discussed this meeting with President Nixon. Haig felt confident that Ziegler was on top of the matter and had the details. Ziegler has stated that he consulted with both the president and Rebozo to confirm that the May 20, 1973 Camp David meeting was only 5 or 10 minutes long. Warren stated that Ziegler confirmed that Rebozo and Danner had met with President Nixon at Camp David for 5 or 10 minutes. Warren did not check either the Cardex or the presidential logs to determine the length of the meeting. Danner, in subsequent testimony to the Senate Select Committee, has reconfirmed his testimony that the meeting he attended with President Nixon and Rebozo lasted at least 1 hour. Abplanalp has stated that he had no knowledge of the $100,000 Hughes contribution which Rebozo received from Danner. Abplanalp recalls that he had only seen Danner 3 times in his life. The third was in May 1973. Abplanalp has never had any conversations with Danner concerning the Hughes contribution. Shortly after the May 20, 1973 Camp David meeting, Rebozo told Haig of his involvement in the Hughes contribution. This is the only conversation Rebozo recalls having with Haig concerning the Hughes contribution. Haig testified that Rebozo did tell him of the Hughes contribution and his involvement with it. Haig did not counsel Rebozo to return the money. On May 23, 1973, William Simon received a telephone call from General Haig. Haig, at this time, requested an update of information concerning the Hughes contribution, which Rebozo received. Simon recalled that this information had been given to the White House long ago, since Rebozo's name had appeared on sensitive case reports. After the time of Haig's telephone call, Simon called Don Alexander, Commissioner of the IRS, and asked for an update on the IRS investigation into Hughes' $100,000 contribution to Rebozo. Alexander immediately sent a memo to Simon, which detailed the facts of the case. After receiving this memo, Simon called General Haig to inform him that Rebozo was going to be investigated by the IRS concerning his involvement with the Hughes contribution. Simon stated that he thought this was a matter Simon should discuss with the White House counsels, Buzzhardt and Garment. After Simon's conversation with Haig on May 23, 1973, Simon testified he discussed with Len Garment the status of the IRS investigation of Rebozo. During his conversation with Garment, Simon used the memo that Alexander had previously supplied to him. According to Simon's log, he was in contact with General Haig, Len Garment, and Don Alexander on May 23, 1973. Sometime after May 23, 1973, Haig met with White House counsels Garment, Chapman Bowes, and Fred Buzzhardt to be briefed on the IRS investigation of Rebozo. This meeting took place in Haig's office. It was decided that Haig should inform the president of this investigation, since it was a matter which could be potentially embarrassing to the president. It was also decided that there should be no discussions between White House counsel and Rebozo concerning the IRS investigation. Garment suggested to Haig that Rebozo should get a qualified tax attorney, and that if Rebozo needed a recommendation, Garment would provide one. Haig testified he thereafter met with President Nixon to brief him on the IRS investigation of Rebozo. Haig told the president that the White House counsel felt that Rebozo should have a competent tax attorney and that, if necessary, they could suggest someone for him. The president told Haig to tell them to do so. It was Haig's general impression that the information he furnished President Nixon concerning the IRS investigation of Rebozo did not come as news to President Nixon. Haig stated, President Nixon just shrugged it off, and as a matter of fact handled it with a number of ongoing problems that Haig was discussing at the time. 2 or 3 days later, Haig told President Nixon that Garment had recommended Kenneth Gemmell as a possible attorney for Rebozo. The president then told Haig to give this name to Rebozo on the following weekend when both Haig and Richard Nixon would be in Key Biscayne. On the following weekend, which would be either the last weekend in May or the first weekend in June 1973, Haig gave the name and address of Kenneth Gemmell to Rebozo. Haig testified that, at that time, Mr. Rebozo took it and said he did not know what he would do with it, but he obviously was well aware at that time of the IRS interest in the Hughes $100,000. There is no question about it. Rebozo has testified that someone in the White House suggested Kenneth Gemmell to him as a good tax attorney. I had heard of Ken Gemmell before, and I had been told when all of this business started that I would probably need Washington counsel, so I got hold of him. On June 8, 1973, Gemmell received a telephone call from Rebozo. Gemmell testified that Rebozo told him that, Garment says that I should come see you about a problem. Rebozo did not give any details to Gemmell concerning his problem at this time. He merely set up an appointment to see Gemmell on June 11, 1973. Both Gemmell and Rebozo have testified that they met on June 11, 1973 in Gemmell's Philadelphia office. During this meeting, Rebozo explained to Gemmell that he had been interviewed by 2 IRS agents concerning the $100,000 campaign contribution. Rebozo then described to Gemmell the events surrounding his acceptance of the $100,000. Gemmell has testified that at no time did Rebozo ever indicate to him that Rebozo had consulted with other lawyers. Gemmell recalled that on June 12, 1973, he also called Len Garment to tell him that Rebozo had been to see him. Gemmell recalled that Garment said, I am glad he is in good hands. You handle him as a privileged client and do not tell me anything about it. Gemmell said, I am to handle him as a privileged client, and Garment said, yes, do not tell me anything about it. And that was the end of that. General Haig recalls that during a subsequent conversation he had with Garment, Garment told him Gemmell had been contacted by Rebozo to represent him in the IRS matter. Gemmell stated that on June 18, 1973, he called Rebozo and told him that he and Wakefield should go to the safe deposit box which they held jointly that contained the $100,000 Hughes contribution. Both Wakefield and Rebozo were to count the $100,000 and make a list of the serial numbers from each of the bills to be used as a receipt and also a way to identify the bills that were returned. Rebozo asked Gemmell if he thought it would be advisable to have someone from the government there, such as the head of the FBI in Miami, to witness this operation. After some consideration, Gemmell told Rebozo that it was a good idea since an FBI agent may be able to determine whether the money had been in the same location for a given period of time. Kenneth Whitaker, SAC Miami, FBI, has testified that Rebozo called him on June 18, 1973, and offering no explanation, asked him to come to the bank immediately. At around 10 a.m., Whitaker met with Rebozo in Wakefield at the Ivy Biscayne Bank. Rebozo then explained to Whitaker that in 1969 or 1970, he had received $100,000 in campaign contributions from Danner, a representative of Howard Hughes. Rebozo told Whitaker that this contribution was placed in a bank vault and had never been used or dispersed. Whitaker has testified that Rebozo wanted him to see if he could determine the age of the money. After discussing the money, Rebozo, Wakefield, and Whitaker joined Margaret Barker, Rebozo's sister, and entered the bank vault. Each of them signed the access card, and then Rebozo removed the safe deposit box. Whitaker has stated that the safe deposit box had 2 large brown envelopes, the contents of which Rebozo emptied on the tables. These envelopes contained 10 to 12 packets of money, approximately 3/4 of an inch thick. These packets were all $100 bills and appeared to be new. Whitaker has stated that, after he saw the money, he told Rebozo that there was no way he could determine the age of the bills. Whitaker stated that he did initial 6 or 7 of the $100 bills in the upper left-hand corner for identification purposes only. After they had completed counting the money and making a list of serial numbers, they discovered that there was an extra $100 bill. Rebozo called Kenneth Gemmell to tell him that the list had been completed. Gemmell suggested that Rebozo try to contact Danner and that both of them should be in Philadelphia the following morning. On June 19, 1973, Rebozo met with Gemmell in Philadelphia. Danner, however, did not show up. Gemmell stated that in a telephone call, Danner said that Chester Davis would call. When Davis did call, Gemmell explained to Davis that Rebozo wanted to return the Hughes contribution. Gemmell and Davis agreed to meet in Washington, D.C. on June 21, 1973. After Gemmell's conversation with Davis, Rebozo told Gemmell that he had the money with him in a briefcase. Since Gemmell was not willing to accept responsibility for the money, Rebozo decided to bring it with him to New York and have Griffin hold it until its return could be arranged. Rebozo then gave Gemmell Griffin's name and telephone number and asked him to contact Griffin after a date was arranged for the return of the money. Gemmell agreed. Rebozo has testified that later that afternoon he met with Griffin at the Hudson Valley National Bank in Yonkers, New York. Rebozo explained to Griffin that he had just left a meeting in Philadelphia with Gemmell where he had hoped to return the money. Rebozo's efforts, however, were frustrated, and he wanted Griffin to hold it until its return could be arranged. Griffin agreed to hold the money in a safe deposit box at the Hudson Valley National Bank. Griffin testified that while Abplanap was in the area during this conversation, he didn't hear it. Rebozo assured Griffin that within the next few days he would receive a call from Ken Gemmell, who would tell him when the money should be returned and where. On June 21, 1973, Gemmell has testified that he met privately with Chester Davis in Davis's room at the Madison Hotel. After reviewing Danner's statement to the IRS, Gemmell and Davis discussed the discrepancies between Danner's and Rebozo's recollection of the delivery of the money. Gemmell has stated that as far as he was concerned, none of these discrepancies affected the return of the money. Davis agreed to arrange for the return of the money and promised to be in contact with Gemmell within a few days. Gemmell has stated that on Monday, June 25, 1973, Davis called and told him that the money could be returned to the Marine Midland Bank, 140 Broadway, New York City, New York, on Wednesday, June 27, 1973. Since Davis was planning on being out of town on June 27, 1973, he told Gemmell that Walter Glaser, the office manager at Davis's law firm, would accept this money on behalf of Howard Hughes, and as previously agreed upon, the money would remain in a safe deposit box until IRS agents had an opportunity to examine it. Gemmell called William Griffin and asked him to meet in New York on June 27, 1973, at the Marine Midland Bank. Since Griffin and Gemmell had not met, Gemmell agreed to produce a copy of the list of bills which Rebozo, Wakefield, and Barker had prepared earlier as a form of identification. Griffin met with Gemmell and Glaser at the Marine Midland Bank on June 27, 1973. After Gemmell provided him with the receipt which Rebozo had earlier prepared, Griffin turned the money over to them. After a brief discussion, Griffin left. After Griffin's meeting at the Marine Midland Bank, he called Rebozo to tell him that the money had been returned. Rebozo has testified that shortly thereafter, Rebozo told the president that the Hughes contribution had been returned, and the president once again assured Rebozo that that was the right thing to do. End of Section 17. Recording by Suzik.
Section 18 of the Watergate Report, Volume 3. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. Chapter 8, The Hughes-Rebozo Investigation and Related Matters, Part 11. 9. The IRS Investigation of Rebozo. The evidence set forth below indicates that the Internal Revenue Service investigation of Rebozo was postponed several times, was handled through oral rather than normal written reports, included advance notice to the President and Rebozo, did not inquire into the relevant periods given in testimony and evidence available, allowed Rebozo's attorney, rather than the IRS, to obtain information from third-party witnesses, did not include additional interviews with Rebozo, even after the IRS had learned Rebozo had altered his previous statements, included notice to Rebozo that the IRS did not intend to pursue any criminal investigation of the matter, included notice by the IRS to Rebozo and his attorney that the Special Prosecutor's Office had sought and obtained disclosure of evidence regarding Rebozo, involved the use of extra personnel at the request of the taxpayer. The Internal Revenue Service first learned of a relationship between Charles G. Rebozo and the Hughes Tool Company in December of 1971 during the investigation of John H. Meyer. Meyer, an employee of Robert Maheu, had allegedly received millions of dollars from the fraudulent sales of mining claims to Hughes. Because of Meyer's relationships with a variety of political figures, including F. Donald Nixon and Edward Nixon, IRS-sensitive case reports were prepared on a monthly basis, relating information to alert IRS officials and the Secretary of the Treasury of an IRS investigation that might touch upon prominent and therefore newsworthy individuals. Former Secretary of the Treasury Schultz determined whether information from the sensitive case reports should be brought to the President's attention. The December 1971 sensitive case report indicated that Mr. Rebozo had instructed Meyer to be unavailable for an IRS interview because it was feared Meyer might disclose his association with Donald Nixon in connection with the sale of mining claims and rebates from the claims. Former Commissioner of the IRS, Johnny M. Walters, stated to the committee that he advised Secretary of the Treasury John Connolly on March 3, 1972, of the allegations relating to Rebozo's advice to Meyer to make himself unavailable. In addition to the Meyer investigation, the IRS was also conducting an intensive investigation of the Hughes organization that was described by former Commissioner Walters. This Hughes project investigation was a mammoth undertaking because the Hughes organization is so diverse and so widespread that we required a substantial number of agents, special agents and others, to carry on the investigation. I forget, but I have a recollection that at one point we had approximately 50 people on this thing, and I could see it going on forever. As part of the above investigation, special agents of the IRS interviewed Danner on May 15, 1972, in the offices of the Hughes Tool Company in Houston, Texas. On that occasion, the IRS received testimony under oath from Danner that he had, in fact, delivered 2 packages containing a total of $100,000 in cash to Charles G. Rebozo. Examination by this committee of sensitive case reports provided by the IRS reflects no mention of the information received concerning the receipt by Rebozo of the $100,000 until an entry on April 26, 1973, which referred to a telephonic contact made by the IRS with Rebozo. The sensitive case reports do reflect, however, on a continuing basis, information relating to amounts paid to former chairman of the Democratic National Committee, Larry O'Brien, from the Hughes Tool Company, pursuant to a contract. Former Commissioner Walters recalls Mr. Rebozo's name surfacing in the late spring or early summer of 1972, and a request by the IRS to interview both Rebozo and F. Donald Nixon with regard to matters previously mentioned. However, Walters stated that he decided, as is reported more completely in this report elsewhere, that the policy of the IRS should not be to interview sensitive political figures during the campaign year of 1972. It is also pertinent to note, however, the IRS policy did not prohibit the continued investigation of Larry O'Brien after communications were received from John Ehrlichman. Rebozo was finally contacted by IRS agents from the Las Vegas office on April 26, 1973, and was interviewed on May 10, 1973. After the results of that interview were furnished to the Washington, D.C. National Headquarters, a decision was reached to conduct an investigation and audit of Rebozo, but that the investigation would be conducted by the Jacksonville, Florida office. The District Director of the Intelligence Division, Troy Register, assigned Agent John Bartlett to be in charge of the Intelligence Division criminal fraud side of the investigation. Bartlett and Agent Burt Webb from the Audit Division met with Rebozo's attorney, Kenneth Jamil, on July 10, 1973, and advised Jamil that they were assigned to make an examination of returns of Rebozo for the years 1968 through 1973. Mr. Jamil objected to any examination of 1968 or 1969 or 1973 records, claiming that the statute of limitations had already run out on 1968 and 1969, and that 1973 records were not relevant. Agent Bartlett responded by indicating that Rebozo had previously told the IRS that he thought the money had been delivered in 1968 and 1969, and that there was other information relating to money in 1968. Despite this initial position, the Internal Revenue Service ultimately agreed not to require production of records relating to 1968, 1969, or 1973. In addition, on that same date, Bartlett's notes indicate that he advised Jamil that the IRS would not contact third-party witnesses, but would allow Jamil and Rebozo to obtain information needed by the IRS from third parties. Had the IRS in the spring of 1973 required the production by Rebozo of the 1969 records, the agents would have observed then that Rebozo had provided payments for the personal expenses of President Nixon. Bartlett and Webb again met with Rebozo on July 24, 1973, apparently to discuss leaks of information Rebozo charged came from the IRS. According to Bartlett's notes, the IRS agents asked Rebozo, for reasons not explained, whether he had been contacted by Cox's commission, and he answered in the negative. Agents Bartlett and Webb again met with Rebozo on August 17, 1973, at which time Rebozo advised them that the president was flying in that night to see Rebozo and wanted to go out to California with him, but Rebozo did not think he would go because he wanted to stay and finish up the IRS business. Mr. Rebozo indicated to the IRS agents that he would like to pay to have additional agents put on the investigation in order that it would be finished more quickly. After making that request the second time, Rebozo mentioned to the IRS agents that the president had phoned him 15 minutes after his speech on the previous Wednesday. Mr. Bartlett has advised this committee that, pursuant to Rebozo's request, Mr. Bartlett discussed this issue with his superiors, and additional agents were added to the investigation. On October 10, 1973, IRS agents met with Attorney Jamil at the University Club in New York City and advised Jamil that the investigation had developed nothing new. Mr. Jamil then requested that the IRS furnish him with a copy of the interview previously conducted by the IRS on May 10, 1973, with his client. Bartlett provided a copy of that interview to the taxpayer's lawyer, who made notes of his client's prior statements. During the October 10th meeting in New York, Agent Bartlett inquired of Mr. Jamil as to whether Mr. Rebozo had ever informed President Nixon of the receipt of the $100,000. In response to that request, Mr. Jamil phoned Agent Bartlett at 10 a.m. on October 12, 1973, and related to him that he had talked to Rebozo, who now indicated that he had in fact told Rosemary Woods that he had placed the $100,000 in the safe deposit box. Agent Bartlett's response was to ask Rebozo's lawyer if Woods would be available for an interview. Jamil said he didn't know, but that he would find out if they so desired. Bartlett indicated that he did not need the information at that time. Jamil again telephonically contacted Agent Bartlett on October 16, 1973, and talked between 9:30 and 9:32 a.m. At that time, Jamil advised Bartlett that after their conversation the prior week in New York, Jamil called and asked Rebozo whether he had discussed the money with the president. Jamil said that Rebozo told him that he had told the president in Key Biscayne between the election and when the money was returned, which Rebozo believed was in the spring of 1973. Bartlett asked Jamil when it was that Rebozo had advised Miss Rosemary Woods, and Jamil said shortly after the receipt of the money. Bartlett then asked about access to Miss Woods and was told that they probably could get a statement from her as to what she knew about it. Bartlett had another telephonic communication with Jamil on the following day, October 17th, and Jamil advised Bartlett that he would get on the phone the next day with regard to the letter from Rosemary Woods. Bartlett advised Jamil, "I told him that we had nothing new basis at present, that I thought nothing serious would develop, but we had to wait to see what might come up in Watergate or Cox before making a final decision." Bartlett has indicated to the committee that he intended to mean by this quoted language that the IRS could not state that they had cleared Rebozo while another investigative body had an ongoing investigation. Jamil testified that he had no recollection of any discussion of the special prosecutor at all with Agent Bartlett. Agents Bartlett and Webb met with Rebozo at his bank on October 18, 1973, and indicated that they had advised Jamil about the results of the investigation, and I, Bartlett, don't anticipate at this time any action by intelligence, final decision still pending. Bartlett has explained that the information was communicated to Rebozo so that he would understand that there would be no continuing criminal investigation by the IRS of the matter. Bartlett's handwritten notes further indicate that on that date he advised Rebozo that disclosure of information and evidence obtained by the IRS had been granted to Special Prosecutor Cox's office. Agent Bartlett has indicated to the Select Committee that he disclosed this information to warn the taxpayer under investigation that anything he might say might be evidence against him in the grand jury. Agent Bartlett conceded, however, that when he read the taxpayer his Miranda warning rights in his earlier interview on July 10, 1973, the taxpayer was then advised the information he provided could be used against him in a criminal proceeding. Agent Bartlett's notes also reflect that he had a prior telephonic communication with Jamil on October 18th between 9:30 a.m. and 9:38 a.m., and the notes include the words, "Call after meeting with Cox, Fred Buzart, White House, 486-1414, and 1. I told Jamil about disclosure to Cox." According to Bartlett, these notes indicate that Jamil was informed by Bartlett even before Mr. Rebozo that Special Prosecutor Cox's office had received a disclosure of IRS information with regard to the receipt by Rebozo of $100,000. The notation, with Buzhardt's name on it, according to Bartlett, refers to the fact that Jamil was to contact Buzhardt to obtain a letter from Rosemary Woods reflecting her information with regard to the receipt of $100,000 by Rebozo. While attorney Kenneth Jamil could not recall discussions with Bartlett with regard to Special Prosecutor Cox, he admitted to having a conversation with White House counsel Fred Buzhardt, but refused to discuss the substance of it on the grounds that it was protected by the attorney-client privilege. White House counsel Fred Buzhardt testified that he recalled having received a request from Mr. Kenneth Jamil to see if I could get some answers to some questions for an Internal Revenue agent. I believe that pertains to this from Miss Rosemary Woods. I think you submitted to me a list of questions which I provided to Miss Woods. Miss Woods gave me the answers. I drafted a letter for her to a revenue agent or somebody with the IRS, and I believe it was Jacksonville, Florida, but I do not recall for sure. That is the only thing I recall doing with respect to this at all. Fred Buzhardt further testified that he did not remember the questions that the IRS wanted answered, that he recalled the subject was about whether Miss Woods had a conversation with Mr. Rebozo, but he could not recall the subject matter of the alleged conversation. Buzhardt did not recall whether he saw Woods in person or contacted her by telephone, but he did recall, I discussed the questions with her, and I asked her what the answers were and would she answer them for the IRS, and she said yes. She gave the information, and I prepared the letter for her, as I recall, or a draft, and sent it over to her. And as I recall, she sent it back to me, and I mailed it. I think, as I recall, I sent her the draft, and I sent an envelope addressed to the IRS. Buzhardt did not recall whether Woods answered the questions orally or in writing, and also did not recall that after the letter was prepared, typed, and signed that he had taken it back from Woods, had made some changes on it, had it retyped and re-signed by her. Buzhardt did not recall whether between the time the letter was typed and the time it was sent, he had contacted any other individual with regard to the contents of the letter, but admitted it is possible. Buzhardt could not recall how long it was between the time Jamil requested the letter and Buzhardt's first contact with Woods with regard to the letter. He did not recall whether any changes had been made in the substance, content, or body of the letter prior to the time it was sent, and when asked, "Did you furnish a copy of that letter to any other individual?" Buzhardt replied, "I do not know." When asked if he had made any changes on the letter that was to be signed by Woods, Buzhardt answered, "Well, I don't have a recollection of it, Mr. Lenzner. I am sure I wouldn't have made changes unless there was some outside input, because I didn't know anything about the matter. I had no idea what the answers to the questions were, so I would have had to have had some input from outside if I made changes. They had to come from Miss Woods. They couldn't have come from me because I had no earthly idea about the matter one way or the other." Buzhardt could not recall whether he ever asked Woods, the president's personal secretary, if she had ever discussed the matter of the $100,000 from Mr. Rebozo with President Nixon or anyone else at the White House. Woods testified concerning the letter that Mr. Buzhardt came in and said that the IRS is apparently in there checking all, or they're going over Mr. Rebozo's files. Mr. Buzhardt wanted to give them a letter on the Hughes loan, the Hughes contribution, and he asked if I would be willing to sign a letter they could give to the IRS. And I said yes, I would, and I gave him the best of my knowledge on it. He wrote the letter, and then, as I say, it was typed twice because he just changed a couple of words in the letter. There was no major change. I don't even remember whether he changed to or by or what it was, because he prepared the letter and Mrs. Acker typed it. Woods testified that she did not know whether Jamil had asked for the letter. Miss Woods was sure, however, that Fred Buzhardt left her office with the letter, and then returned after a period of time with some changes. Woods did not recall what changes were made in the body of the letter. In addition to the fact that Miss Woods's letter was signed and sent to the IRS on October 18, 1973, General Alexander Haig, the Chief of Staff of the White House and H.R. Haldeman's successor, telephonically communicated to Attorney General Elliot Richardson on that same date a re-expression of the President's concern about the extent to which Mr. Cox was getting into things that he thought were outside the Charter. Former Attorney General Richardson testified before the U.S. Senate Judiciary Committee that Haig advised him of the President's concern, and he didn't see what Mr. Cox's charter had to do with the activities of Mr. Rebozo, especially when there had already been an investigation of the whole matter by the Internal Revenue Service. Richardson further testified that General Haig expressed not only that the investigation was outside of Mr. Cox's charter, but also that the Internal Revenue Service was giving Mr. Rebozo a clean bill, that it was the most thorough investigation in years and they are intimidated. This is no longer an acceptable basis for a government to run. That was October 18th, but there was no request that anything be done about Rebozo, and I had no conversation about Rebozo with Mr. Cox at all. When asked specifically about the October 18, 1973 telephone call with then Attorney General Richardson, General Haig answered as follows: "Yes, I do, and again in the context of an indication. At the time, we were very concerned about another matter with respect to Mr. Cox and Mr. Cox's failure to give us a response, and the whole subject to Mr. Cox's frame of reference, activities, and investigations came up. As I recall, Mr. Richardson mentioned to me something about a Cox activity at that time that I knew nothing about, involving Ablanalp and his discussions with Mr. Cox about that. Well, I did not raise that. Elliot raised it. I raised this strictly in the context of the problems we were having with Mr. Cox on another issue, and what I would want to make very, very clear is that the Rebozo matter had nothing to do with the considerations and deliberations made with respect to Mr. Cox in that week of October." General Haig was also asked if he called Attorney General Richardson at the instruction of the President on October 18th, and he responded as follows: "No, it was not in that specific sense. And again, you have to put yourself, if you can, to portray the kind of dialogue that was going on during that week. I was frequently in the habit that week, and at other times, of having a discussion with the President and picking up the phone and calling Elliot Richardson. On that occasion, I may have expressed this as being of presidential concern, and I'm sure, if I did, that I would have had reason to know that, either because I knew the President's thinking or because he specifically told me so." General Haig further denied that the President ever expressed any concern about Special Prosecutor Cox's investigation of Rebozo, and in fact could not recall any statement that the President made in discussing the $100,000 furnished to Rebozo, except the President's concern about the way the investigations were being handled. In indicating that the President had not expressed concern with regard to the Special Prosecutor's investigation of Rebozo, General Haig did state, however, "The concerns I had about it were very limited. In the fall, there was some concern about a number of areas that the Special Prosecutor may or may not have been involved in the context of his charter. Mr. Buzhardt, I know, has discussed it with me, and I know he discussed it with Attorney General at that time, Elliot Richardson." General Haig was also asked the following: "Mr. Lenzner, do you recall representing to Mr. Richardson that the President was concerned that Mr. Cox was getting into an investigation of Mr. Rebozo?" General Haig: "I may have. I know our counsel was concerned about it." Mr. Lenzner: "Which counsel was that?" General Haig: "Mr. Buzhardt and I discussed it. We discussed that, and we discussed another area of activity that Mr. Cox was into, and I know there was some ongoing discussions with Mr. Buzhardt and Mr. Richardson." Mr. Buzhardt, however, testified directly in conflict with this above testimony. Mr. Lenzner: "Now, on or about the same date as this letter, the October 18th letter of Miss Woods, Do you recall having any discussions with any other individual with regard to the initiation by Special Prosecutor Cox of an investigation into the receipt by Mr. Charles G. Rebozo of $100,000 from the Hughes Tool Company? Mr. Buzhardt: No. Mr. Lenzner: Have you at any time become aware of the fact, aside from the news media, that Mr. Cox had initiated an investigation into this matter? Mr. Buzhardt: I may have been. I don't recall it. Mr. Lenzner: Do you have any recollection of ever discussing that issue, the issue of the Cox investigation of the Rebozo receipt of $100,000, with General Haig? Mr. Buzhardt: No, I don't recall it. Mr. Buzhardt further testified that he did not recall whether he was aware that General Haig had made the October 18th call to Attorney General Richardson at the time it was placed. Jamil also testified that Bartlett made an agreement with him that when he received the results of the Federal Reserve Bank's search of the dates on the currency returned by Rebozo to Hughes, he would furnish that information to Jamil. In addition, Agent Bartlett's handwritten notes of November 25, 1973, reflecting a telephonic contact with Jamil, indicate, "Have we heard from the Federal Reserve concerning the money? Answered in the negative." Jamil also asked Bartlett if IRS had any evidence of funds going to a trust account of the President, and Bartlett told Jamil that they had not. Following Jamil's testimony on May 29, 1974, his counsel furnished additional information Jamil received from General Haig, to wit: Mr. Jamil now recalls 2 additional conversations with General Haig concerning the $100,000 contribution. One occurred a few days before Mr. Jamil left for China, and the other occurred possibly 2 months earlier. To the best of Mr. Jamil's recollection, General Haig in both conversations indicated that the Federal Reserve Bank report was on the way and there may be a problem. On both occasions, Mr. Jamil recalls that he replied that the revenue agents had agreed to give Mr. Jamil a copy of the Federal Reserve Bank report and that he would wait and see what the report said. In addition to agreeing to provide the taxpayer not only with a copy of his interview but with a copy of the results of the Federal Reserve Bank report, the IRS apparently obtained access to only a limited number of cashier's checks purchased by Mr. Rebozo, despite the fact that a considerable number of cashier's checks were purchased by the taxpayer under the names of Charles Gregory and Anita Reynolds. The IRS further agreed not to photocopy any of the cashier's checks to which they had access, and did not obtain information from the checks themselves regarding who received the proceeds of such checks for the purpose of which the checks were issued. General Haig testified that he discussed the IRS investigation of the Hughes contribution with President Nixon several times. I would say there were several brief discussions when it came to my attention, to my knowledge. Then there was a prolonged period when it never came up at all. Then I may have discussed it once or twice when the investigation was nearing a conclusion. Haig also testified that he was present at discussions in Key Biscayne between the President and Mr. Rebozo regarding the investigation of Mr. Rebozo. On one occasion, Haig said the President advised him that Rebozo had been before the Select Committee for testimony. General Haig further testified that on one occasion the President advised him of information the President received from Mr. Rebozo. I think he probably said that Mr. Rebozo did not use the money because he was afraid it would be troublesome, and he put it in the safe deposit box and left it there. I know more recently the President expressed to me his absolute conviction that none of that money was given to Miss Woods or to his family, his brothers. Finally, Secretary Shultz stated to the committee that the only person he discussed the Rebozo tax audit with was General Haig, and that this occurred in late 1973. End of Section 18. Recording by Maria Casper. Section 19 of the Watergate Report, Volume 3. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. Final Report of the Senate Select Committee on Presidential Campaign Activities, Volume 3, Chapter 8, The Hughes-Rebozo Investigation and Related Matters, Part 12. IRS Audit of Larry O'Brien. It was during the course of the IRS investigation of the Hughes Tool Company that special agents of the IRS, in a sensitive case report, stated that their investigation had disclosed that the Hughes Tool Company made substantial payments to Lawrence F. O'Brien and Associates during 1970. This same sensitive case report also referred to possible improprieties by Rebozo, Don Nixon, John Meyer, and others. Because some of the names mentioned were politically prominent, this information was summarized in a sensitive case report brought to the Secretary of Treasury's attention. Roger Barth, who was assistant to the Commissioner of the IRS, testified that in May 1972 he received a sensitive case report which arose out of the Hughes Tool Company investigation. Now, when I received this report, I of course went through the normal procedure of taking it to Secretary Shultz, and either he or I transmitted a copy of the sensitive case report of the Hughes project to John Ehrlichman at the White House, because of the fact that there were allegations or representations in the report of possible wrongdoing by Mr. Rebozo and Mr. Nixon, the President's brother or brothers. Sometime thereafter, not very long thereafter, I was either called on the phone or went over, I can't remember which, to Mr. Ehrlichman's office, and I think I went over there as a matter of fact, and he asked that he be kept advised of the development of this Hughes project as it related to Mr. Rebozo and the Nixon brother or brothers. And in the conversation about that, he raised the question of whether, what would be the tax treatment or the implication of the payments to Larry O'Brien. If this were a political contribution by the Hughes Tool Company, it could conceivably be a violation of the Corrupt Practices Act, and if it were deducted by the corporation, it could be a violation of the tax laws. On the other hand, if it were compensation for consulting services for Mr. O'Brien or his firm, then he raised the question of would this be reported by Mr. O'Brien. I thought this was a reasonable question that he asked, and I told him I would check it out. But I did not want to make any contact with our field personnel through normal channels, because I did not want to give the impression I was, on behalf of the Commissioner, trying to instigate any audit of Mr. O'Brien. So what I did was go to the Assistant Commissioner of Inspection, Frank Giebel, and asked for Lawrence O'Brien's tax returns. I asked that they get them in a way that the agents working on the case in the field wouldn't know that I requested them, and they did this, and what I did, I just looked at the tax returns of Mr. O'Brien and his consulting firm, and made sure that there was enough gross income reported for those years to cover the amount reported. Ehrlichman has testified that he received sensitive case reports beginning in 1969, when he was counsel to the President, and continuing throughout his tenure at the White House. Ehrlichman stated that the President and the Secretary of the Treasury had worked out the arrangement whereby sensitive case reports would be transmitted to the White House through Ehrlichman. Johnny Walters, who was Commissioner of the IRS from August 1971 through May 1973, has testified that it would be quite proper for the Secretary of the Treasury to alert the White House to sensitive case reports. Walters, however, has also testified that he had no knowledge that Barth was providing copies of sensitive case reports to Ehrlichman. Walters stated that it would have been out of the routine and I would worry about that. Ehrlichman testified that he received the sensitive case report from Barth, and that after receiving it called Shultz to find out what the status of the O'Brien audit was. Shultz at this time had only been Secretary of the Treasury for a few weeks, and was not even aware that O'Brien was being audited. Schultz told Ehrlichman he would get this information and report back to him. After his conversation with Ehrlichman, Schultz called Walters to get the status of the O'Brien audit. Walters has testified that Secretary Schultz stated to me that the White House had information that indicated that Mr. O'Brien may have received large amounts of income which possibly might not have been reported properly. The Secretary asked me if I could check, and I said I would check. I then asked the Assistant Commissioner of Compliance, Mr. Hanlon, if he would determine whether Mr. O'Brien had filed returns and the status of those returns. A few days later, Mr. Hanlon reported orally to me that IRS had checked, that Mr. O'Brien had filed returns, that those returns reflected large amounts of income, that the returns had been examined, that a relatively small deficiency was indicated in one which Mr. O'Brien had paid, and that the audit and examinations were closed. Now, I reported this to the Secretary at some point and told him just that, which meant that there was nothing else, that IRS has performed its function and responsibility. Some time later, the Secretary indicated that that had not completely satisfied Mr. Ehrlichman, and wasn't there anything else that could and should be done. And of course, by this time, IRS had already concluded that it should interview Mr. O'Brien in connection with these payments from Hughes. I told the Secretary that we could interview Mr. O'Brien and just be sure that the amounts reflected in the return covered the particular amounts from the Hughes organization. Walters has stated that at a later date, Schultz confirmed to him that it was Ehrlichman who told Schultz about the money O'Brien received from Hughes. Walters testified that in late 1971 or early 1972, the top management team of IRS discussed the approaching 1972 presidential elections. The IRS deliberately concluded that anything that was politically sensitive should be postponed until after the election. Walters said they did not want to be involved in politics on either side, and so wherever possible, politically sensitive interviews were to be postponed until after the election. Because of this policy, the IRS did not interview Rebozo or Don Nixon until 6 months after the election. The IRS, however, did succumb to pressures from the administration and interviewed O'Brien before the 1972 election. Walters further testified, "With that policy in mind, it's obvious that any interview of Larry O'Brien would have been postponed until after the election. So I think the IRS would not have conducted that interview until after the election, had it not been for the generation of pressure from the White House, Ehrlichman." In the meantime, both Barth and Schultz had kept Ehrlichman apprised of the status of O'Brien's audit. Schultz stated that there had been an unspoken feeling that the IRS tended to be rather easy on Democrats while they were particularly hard on Republicans. Ehrlichman had especially expressed these kinds of feelings to Schultz. It was Schultz's objective, therefore, to be sure that a proper audit was conducted on O'Brien. From time to time, Schultz called the IRS to see how the proceedings were going, and he would then call Ehrlichman to report on the status of the O'Brien audit. Barth has testified that he advised Ehrlichman that after Barth checked O'Brien's tax returns, there appeared to be enough gross income to cover the amounts that Hughes reported he had paid to O'Brien. According to Barth, this was the first and only time that he had ever obtained an individual's tax returns to verify information he had obtained through a sensitive case report. Barth testified that Ehrlichman knew he was going to obtain O'Brien's tax returns and, in fact, encouraged him to do so. Ehrlichman testified that there were good political reasons to go after O'Brien, since O'Brien was the head of the Democratic Party. After Ehrlichman saw O'Brien's name in the sensitive case report, he said he brought this information to President Nixon's attention. The President was quite interested in the audit of O'Brien, and was especially interested in the fact that O'Brien was on retainer to the Hughes organization, according to Ehrlichman. Ehrlichman, however, did not recall if the President made any specific requests for Ehrlichman to follow up on this matter. Haldeman has testified that the information coming from the Hughes tax audit concerning Larry O'Brien may have revived the White House interest in O'Brien. Haldeman further stated that from the administration's perspective, Larry O'Brien was the only effective Democratic politician in the country, and therefore there was some interest in attacking O'Brien to lessen his effectiveness from a political standpoint. Ehrlichman has testified that Haldeman filled in many of the informational gaps that were left from the sensitive case report concerning O'Brien. For example, Ehrlichman learned from Haldeman that the amount of the retainer O'Brien was receiving from Hughes was quite significant, and recalls that both were impressed by the possibility of embarrassing O'Brien because of a possible overlap of his retainer with Hughes and his tenure as chairman of the Democratic National Committee. On August 17, 1972, Larry O'Brien was interviewed by the IRS. A written report of this interview was sent to Walters, who in turn transmitted the report to Secretary Shultz. By this time, Walters felt that the IRS's interest in O'Brien should be concluded because the taxpayer had filed his returns, reported his income, and paid his taxes. Walters said he had insisted to Shultz that the IRS had conducted an audit and that the case was closed. Walters added that it appeared that Shultz was being pressed. On August 29, 1972, Shultz told Walters that he wanted to meet with both Walters and Barth to discuss the O'Brien audit. Walters testified that both he and Shultz thought they were being backdoored in some fashion, and that in this situation it would be advisable for Barth to be apprised of the specifics concerning the O'Brien matter. During this meeting with Shultz and Barth, Walters explained to Barth that information had come to the IRS from the White House concerning large amounts of money O'Brien made that were possibly not reported. Walters further explained to Barth that the IRS had checked O'Brien's return and that it appeared that everything was proper and the examination was closed. Barth testified that he said that he had read the report on the matter and he felt it was a thorough job. Shultz then called Ehrlichman to give him a final report on the O'Brien audit. Both Walters and Barth were on telephone extensions during this joint telephone call. Shultz and Walters reported to Ehrlichman that the audit report on O'Brien was completed and that everything was in order. Ehrlichman asked Barth if he had read the report and if everything appropriate had been done on this audit. Barth testified he told Ehrlichman that it looked like an appropriate audit and there was nothing worth pursuing any further. Barth recalls that Ehrlichman seemed to take his word for it, and that the only reason Ehrlichman seemed to have was that he was annoyed that it had taken so long for this report to be prepared. Walters testified that toward the end of the conversation, Ehrlichman expressed very strong feelings to Walters concerning the manner in which the O'Brien audit was conducted. Walters testified that as this conversation became more offensive to him personally, he hung up his extension. Shultz recalls that during this conversation, Ehrlichman told Walters that Walters would not go after prominent Democrats even if the facts were there. According to Shultz, this was the only challenge to the thoroughness of the O'Brien audit that he could recall. Ehrlichman stated that the purpose of this joint telephone call was to report to him that the audit on O'Brien had been completed and that it had disclosed no improprieties or delinquencies. Ehrlichman testified that my concern was throughout that the IRS down in the woodwork was delaying the audit until after the election, and that seemed to be the case, that there was a stall on. Ehrlichman also testified that I wanted them to turn up something and send O'Brien to jail before the election, and unfortunately it didn't materialize. During this joint telephone conversation, Ehrlichman said he had his first opportunity to articulate to Walters what his opinion was concerning the job Walters did on the O'Brien audit. "It was my first crack at Walters. George wouldn't let me at him. George wanted to stand between me and his commissioner, and this was the first time I had a chance to tell the commissioner what a crappy job he had done." Ehrlichman did accept the commissioner's view that the O'Brien audit was closed. He says he did not suggest that they reopen the audit on O'Brien at any time, because as far as he was concerned, the matter was closed. Barth, however, has testified that shortly after the August 29, 1972 joint telephone conversation with Ehrlichman, Ehrlichman called him a few hours later. Barth recalls that Ehrlichman just wanted to check to make sure that Barth honestly felt that the IRS audit of O'Brien was conducted properly. Barth told Ehrlichman that he was satisfied with the audit, and according to Barth, Ehrlichman thanked him for his judgment on the matter, and that was the end of the conversation. On September 15, 1972, however, John Dean and H.R. Haldeman met with President Nixon, and according to evidence received by the committee, discussed the IRS investigation of Larry O'Brien. The details of this discussion, however, were not provided to the committee by the White House. In addition, this particular conversation was deleted from the White House tapes provided to the special prosecutor and the House Judiciary Committee, as well as from the transcripts released to the public. End of section 19. Recording by Maria Casper.